We're calling this meeting to order. I know Mr. O'Keefe will be back here soon, so sorry for the delay. We had to thank our witnesses, Ms. Sharyl Attkisson, Mr. James O'Keefe, and Ms. Harmeet Dhillon, for taking the time to meet with us today to share what happens when the free press steps outside of the corporate media's approved talking points. We also thank our host, FreedomWorks, for allowing us to use this space to have a real conversation about these abuses. And I thank my fellow members of Congress, and we have some with us, and you'll see others coming in and out. It's going to look a lot like a regular congressional hearing. And I appreciate their willingness to change schedules to come in to participate in this hearing today. While we are just off Capitol Hill, I think it's for us to roughly abide by our traditional. I'd like to see us abide by our traditional rules of about 5 minutes for testimony, for witness questioning, etc. Whether it's colluding with big tech oligarchs to torpedo negative stories about his corrupt family, or establishing a ministry of truth at the Department of Homeland Security staffed by Democrat activists, President Biden has continued a long-standing tradition of Democrat presidents using the power of government to silence dissent by employing an all-out assault on free speech and the free press. But it does not end there. President Biden is following in the footsteps of his mentor, Barack Obama, whose administration abused the powers of our nation's law enforcement agencies to intimidate and silence journalists reporting on the scandals that plagued his presidency. Today we'll hear first from Sharyl Attkisson, a recipient of numerous Emmy Awards for her investigative journalism, including for her coverage of the Obama ATF Fast and Furious scandal. She was placed under surveillance by the U.S. intelligence operations. Ms. Attkisson will detail how she has confirmed that she and her employer were victims of illegal government surveillance activities and how the perpetrators attempted to cover up their crime and how they have yet to be held accountable. We will then hear from Ms. Harmeet Dhillon, a nationally recognized civil liberties attorney and former journalist, and her client, James O'Keefe, the founder and CEO of Project Veritas, who will outline the abuse that they have experienced at the hands of Biden's FBI and Department of Justice. In 2021, the Biden administration employed the use of a series of secret warrants, orders, and subpoenas to collect communications and contacts of Project Veritas reporters. Under the guise of investigating the whereabouts of Ashley Biden's diary, the Department of Justice spied on Project Veritas, ignored the ruling of a federal judge seeking to ensure that the First Amendment rights of these journalists were protected, and attempted to hide the fact that the government obtained communications for time periods far outside the scope of this supposed investigation. In November of 2021, the FBI even launched a pre-dawn raid on O'Keefe and journalists employed by Project Veritas, seizing electronic devices in a naked attempt to collect information and identify Project Veritas sources. The actions of the FBI were so out of line that even the ACLU issued a statement warning that the precedent set in this case could have serious consequences for press freedom. Unless the government had good reason to believe that Project Veritas employees were directly involved in the criminal theft of the diary, it should not have subjected them to invasive searches and seizures. We urge the court to appoint a special master to ensure that law enforcement officers review only those materials that were lawfully seized and that are directly relevant to a legitimate criminal investigation. The House Judiciary Committee has marked up 2 pieces of legislation in an attempt to limit the use of non-disclosure orders and to protect journalists from abusive overreach by the federal government. And while those bills will help to protect journalists and news outlets, there's still no excuse for the actions taken of the Biden and Obama administrations. And that's why we're here today. I wanted to have this hearing after I spoke with Project Veritas about the recent revelations regarding the FBI using non-disclosure orders to prevent companies from sharing with Project Veritas that they were giving information over to law enforcement, while at the same time a different federal judge had ordered them to use a special master to review information that had been seized. These actions should not have occurred, and those who were involved should be held accountable. Hopefully this hearing today will shed much needed light on the abuse that has occurred, and we as members of Congress will be able to come together to conduct oversight, make needed legislative changes, and ensure that those responsible are held accountable. I thank everyone who is here in attendance today. We look forward to your testimony. And with that, Ms. Attkisson, I turn the time over to you for your opening statement.
Thank you for having me. We can talk about my case if people are interested more specifically, but I'm speaking to some broader abuses in history of FBI and surveillance abuses that I think brought us to the point where they were able to do to me and to many other people what they've done with impunity. So this is a little bit of a look back and timeline that I've built on these issues. Our intelligence agencies, including the FBI, are made up of public servants paid with public money. They operate largely in the dark, and many of them we know do a great job. Unfortunately, even the little evidence that's become public reveals disturbing facts. There are agents and officials who are capable of great abuses, and it's not rare. Too often, the whistleblowers in these cases, when we can find out about them, get punished, while the abusers and criminals get a pass. The implicit message is lost on no one. In 2001, under FBI Director Robert Mueller, new rules called Woods procedures were imposed to stop FBI agents who'd repeatedly gotten caught submitting false information to the Foreign Intelligence Surveillance Court, sound familiar, to spy on U.S. citizens. The new protections at the time required the FBI all the way to the top to strictly verify each fact in a wiretap application. If one fact could not be verified, the whole application was supposed to go back to zero. But 15 years later, we learned after the fact the FBI was still routinely violating these procedures, likely on thousands of wiretaps. What's come of this misconduct and possible crimes implicating at least dozens of agents and probably a lot more? Virtually nothing. Even Mueller stayed oddly silent on the FBI misconduct that he surely would have or could have uncovered in his 2017 investigation. Have those whose information was improperly obtained been notified and their illegally gathered or improperly gathered information disclosed to them or destroyed? No. Going to 2002, NSA whistleblower Thomas Drake revealed the agency was, quote, fine-tuning a new scale of mass surveillance, conducting blanket surveillance of virtually all electric communications going in or out of Salt Lake City during the Winter Olympics. What came of that revelation? The whistleblower was prosecuted for mishandling documents. In 2009, FBI whistleblower Shammai Leibowitz accused intel agencies of serious constitutional violations and illegal abuse of power. What came of that? He was prosecuted for leaking to the media. As the government secretly expanded its surveillance powers in the name of national security, we discovered officials were even listening in on members of Congress, sometimes political rivals. Someone illegally leaked information about private phone calls made by Democrats Jane Harman and Dennis Kucinich, and even leaked actual recordings of Kucinich's calls with Libyan officials. Government agents, as we now know, targeted journalists too, with secret surveillance and subpoenas against then Fox News reporter James Rosen and 20 Associated Press reporters, and they secretly intruded upon and remotely monitored my computers and devices and those of my family while I worked at CBS News. An internal email by a global intelligence firm laid some blame at the feet of then Homeland Security Advisor John Brennan. This email in 2010 read in part, quote, Brennan is behind the witch hunts of investigative journalists learning information from inside the Beltway sources. There is specific tasker from the White House to go after anyone printing materials negative to the Obama agenda. As far as I know, no congressional committee or law enforcement agency bothered to investigate that or even call and ask the authors of the email where they got their information. Brennan went on to head up the CIA, where questions continued to build. Under his watch, as you probably know, 5 CIA officials improperly searched through staff emails of the Senate Intelligence Committee. Brennan denied it, then later apologized after the CIA Inspector General investigated in 2014 and confirmed it happened. In a Senate hearing, Director of National Intelligence James Clapper denied there was any mass surveillance on innocent U.S. citizens. A short time later, in June 2013, NSA whistleblower Edward Snowden proved Clapper's testimony was false. Between Snowden and WikiLeaks, the lid was blown off how massive and intrusive the government surveillance dragnet had grown. How is it that America can find itself in a position so chillingly similar to that of North Korea and the former Soviet Union, where people believe government intel agencies are untouchable, not serving the public good, but to be feared, more powerful than any entity that would watchdog or control them? Calling them, quote, the world's most powerful intelligence agencies, Snowden noted they are, quote, such powerful adversaries that no one can meaningfully oppose them. If they want to get you, they'll get you in time. President-elect Donald Trump received a similar warning from Senate Leader Chuck Schumer after Trump criticized sitting intelligence officials. Schumer said, you take on the intelligence community, they have 6 ways from Sunday at getting back at you. Sure enough, the Justice Department Inspector General, Michael Horowitz, found the FBI and 3 separate hand-picked investigative teams committed egregious errors in targeting Trump associates for investigation and surveillance during the 2016 campaign. Meantime, less than 2 weeks before the 2016 election, the FISA court's lead judge, Rosemary Collyer, secretly slammed Obama intel officials for a series of surveillance violations. In a document made public after the election, she accused the NSA of, in her words, institutional lack of candor, a very serious Fourth Amendment issue, and demanded fixes. And the FBI, as we know, used evidence that turned out to be unverified political opposition research bought by the Clinton campaign and delivered to the FBI and the media. And the FBI response seems to be, how are we, the FBI, to be expected to check the sources of political information that comes to us from political operatives? Since then, in speeches and congressional testimony, FBI Director Christopher Wray falsely claimed there's never been any abuses of surveillance authority known as 702, although the court has documented many examples. And we've remained successfully distracted by one intel propaganda campaign after another. Snowden is charged with 3 felonies in his absence for the U.S. WikiLeaks founder Julian Assange has been destroyed, and the information both of them revealed is seemingly deposited down the memory hole. Snowden described his worst fear was that people will see the lengths the government is going to grant themselves powers unilaterally to create greater control of American society and global society, but they won't be able to take the risks necessary to stand up to fight to change things, to force their representatives to actually take a stand. Rather than demanding accountability, I think we've slipped into sort of a 1984 style of acceptance. Public shock and outrage over the known government abuses has morphed into a numb acceptance. I hear people say, of course the government watches all of us. After CBS News officially announced the spy operation against me, I attended an investigative journalism conference where one executive from each major network pulled me aside and told me they felt certain the government was surveilling them too. Imagine how this impacts what we report and what our bosses allow us to report. The institutions responsible persist long beyond any single administration, and I don't know how at this late date these problems can be fixed, short of reinventing our intelligence infrastructure, and of course, depending on who reinvents it, it could make matters worse. But we do know one thing, that the current path leads only to continued escalation of the abuses.
Thank you so much. Ms. Dhillon, I see you here, and we appreciate you being here remotely, and I'll turn some time over to you for your opening statement.
And thank you for allowing me to appear before
Can you suspend
you.
for 1 second? We need to adjust that volume. They're moving rapidly to fix that, Ms. Dhillon, so thank you.
No problem.
Oh, there we go.
1, 2.
Hey, now we have you louder and clearer than ever.
Okay, great. Well, thank you, Congressman Biggs, members in attendance, and thank you especially for allowing me to appear remotely to discuss an important issue dear to my heart as a lawyer and a civil rights activist, namely the Department of Justice's overreach as it relates to freedom of the press. And I say this as a former journalist as well before I went to law school. In the spring of 2021, it was reported that the Trump administration had authorized secret demands for the phone and email records of reporters at the Washington Post, CNN, and the New York Times. And at that time, the Biden administration launched an investigation. And in May of 2021, President Biden himself called the practice of seizing journalists' records, quote, positively wrong, close quotes. He also said it was simply wrong. When asked if he would seize journalist records, Mr. Biden responded, "I will not let that happen." Pretty decisive. In July, Attorney General Merrick Garland issued a memo forbidding federal prosecutors from seizing journalists' records. We now know that these statements by the current administration were hollow at best. By the time of Mr. Biden's and Mr. Garland's statements decrying the seizure of journalist records as wrong, simply wrong, and something that they would not let happen, the DOJ that they oversaw had already commenced a year-long spying campaign into my client Project Veritas that involved no fewer than 19 clandestine subpoenas, orders, and warrants obtained from 9 separate magistrate judges in one federal judicial district, and whose secrecy was guarded by broad-reaching gag orders, including at least 2 which were obtained without notice to Judge Annalisa Torres, who's overseeing the case. Through this spying campaign, we now know that the DOJ obtained approximately 200,000 Project Veritas emails from Microsoft and countless text messages and Lord knows what else from Apple, Google, Uber, and other still to be discovered vendors. Only 6 months after Mr. Biden's and Mr. Garland's sweeping and reassuring statements about the integrity of their operations with respect to the media, the DOJ raided the homes of 3 Project Veritas journalists, seizing a total of 47 different devices in a span of a few days. Now, why did the Department of Justice seize 200,000 emails and 47 devices from American journalists on US soil, despite Mr. Biden's and Mr. Garland's promises to never let such seizures happen again, at least not on their watch? Well, it just so happens that the journalists whose data was seized were investigating potentially inappropriate behavior by Mr. Biden and his family. In the fall of 2020, confidential sources approached Project Veritas journalists with a copy of Ashley Biden's diary and other materials supposedly belonging to her, materials that had been in the source's possession prior to even contacting Project Veritas. Now, Project Veritas, as responsible journalists would do, investigated what they were given to determine not only if the items were authentic, but also whether the allegations against President Biden or then candidate Biden contained therein were true. Ultimately, Project Veritas decided it would not publish the diary or its contents, and it returned them to local law enforcement in Florida. Now, just like the recent news that reporter Josh Gerstein in Politico lawfully received a United States Supreme Court draft opinion overturning Roe versus Wade, James O'Keefe and Project Veritas lawfully received Ashley Biden's diary. There is no distinction between the 2 journalists' conduct, except one, that Mr. James O'Keefe decided not to publish Ashley Biden's diary and news story while Politico ran with their story. And so while Mr. Biden was telling the public that he would not allow the DOJ to seize materials from journalists, the Department of Justice, under his watch, was secretly and vociferously rifling through reporter emails and phone messages belonging to Project Veritas journalists, some dating as far back as 8 months before Project Veritas even learned about the very existence of Ashley Biden's allegations against her father. What was the need for the government to rifle through these communications for a period of 8 months before the journalists even received the information? I think we all know the answer. The government claims that Ashley Biden's belongings were stolen. They weren't, but this isn't even relevant. In 2001, the United States Supreme Court, in an important case called Bartnicki versus Vopper, made the unequivocal decision that so long as journalists do not commit the alleged theft themselves, they are entitled to receive, investigate, and either publish or not publish the supposedly stolen materials. Another case, Democratic National Committee versus Russian Federation, made it clear that the reporter could even ask for the stolen materials to be turned over to the reporter. This isn't a crime. In America, this is called journalism. It appears that the only defense journalists have today is in the court of public opinion and in pressure to put law enforcement agencies on notice to cease investigations into journalists. Just 2 weeks ago, Los Angeles County Sheriff Alex Villanueva announced that his department would not be pursuing charges against a Los Angeles Times journalist who published allegedly stolen security video footage. But he only backed down after the Reporters Committee for Freedom of the Press denounced his planned investigation of that journalist. When the DOJ ignores federal binding precedent, Bartnicki and others, and the DOJ seizes journalists' emails and phone data, it runs afoul and ignores not just Supreme Court precedent and the law of our land. It also violates the Federal Privacy Protection Act, the current Attorney General's own directive on these matters, the common law reporter's privilege, and finally, the First and the Fourth Amendments to the United States Constitution. And these things can easily happen again and again without proper oversight from Congress, changes in the law, and a change in the attitude of the United States Department of Justice. Thank you.
And I know that you might have to leave at some point, so we excuse you when you need to leave. Thank you.
Thank you.
And now we turn for his opening statement to James O'Keefe.
Congressman Biggs and members in attendance. Microphone. Congressman Biggs and members in attendance, thank you for allowing me the opportunity this afternoon to tell my story. I especially want to thank all members of the House Judiciary Committee for the recent unanimous bipartisan support of new legislation protecting journalists from government overreach. These are important first steps. But as we face a government that in May of 2021 promised the seizure of journalist data is, quote, simply wrong, unquote, and, quote, will not happen, while simultaneously actively seizing journalists' data, it is clear that the framework of journalist protection that relies upon the government to tell the truth, well, that framework is not enough. My home was raided by armed FBI agents in the pre-dawn hours of November 6, 2021. I was the third journalist at Project Veritas handcuffed that November. The FBI took off with 47 devices from our newsroom. The FBI wanted evidence of a crime related to a diary written by Ashley Biden containing allegations about what she described as, quote, probably inappropriate, unquote, behavior by her father, President Joe Biden. The diary and other items supposedly belonging to Ashley Biden were lawfully given to us by sources who had been in possession of those items before Project Veritas was ever even contacted by the sources. And we have a little video clip here of the raid. In short, we did nothing wrong other than the non-crime of investigating a story as journalists do. When we reached out to the Biden campaign for comment, Ashley Biden's attorney, a woman named Roberta Kaplan, responded by saying, quote, we should send to the Southern District of New York, unquote. In just 24 days, Ms. Kaplan got her political favor fulfilled when the Southern District of New York approved the first of 19 secret subpoenas, orders, and warrants, which gave the Department of Justice unfettered access to my and other reporters' newsroom email and phone data, complete with gag orders, preventing us from knowing about the seizures and doing anything about it, including at least 2 gag orders obtained behind the federal judge, Annalisa Torres's back, after she had granted our motion appointing a special master over the Department of Justice, where she said it was to protect our, quote, journalistic privileges, unquote. The Department of Justice's actions are patently unconstitutional, So much so, the ACLU and the Reporters Committee for Freedom of the Press quickly denounced the Department of Justice's seizures. 200,000 of our newsroom's emails were seized. Numerous cell phones, 47 devices. Contrast that with this. To date, the special master has only deemed 355 documents potentially responsive. Yet even these 355 documents are protected under the freedom of the press, an argument the government called recently, quote, a newly invented privilege, unquote, and a, quote, novel theory. Let that sink in. The government even argued that in order to avoid disclosing our confidential journalist data, we must first disclose our confidential journalist data so the government can be satisfied that we are in fact innocent. This is directly in conflict with United States law. The Supreme Court ruled in 2001 in Bartnicki v. Vopper that the mere receipt and eventual return of materials for innocent news-gathering purposes is First Amendment protected activity, period. In the Project Veritas headquarters, there's a sign when you walk into our building. It says, this organization is protected by patriots, referring to the millions of Americans who support our work and afford us the ability to defend the right of journalists to report on stories critical of even the most powerful people and politicians in the world. But what of the unknown reporter? No one knows his name. His wages are printed words. The thirst for truth courses through his blood. He believes in the maxim, even if only one person listens to my investigative report, it's worth doing, because the truth matters. We must protect that person so that what happened to me never happens to him. One, I'm calling on all of you to create a Bartnicki hearing, a requirement that before subpoenas, warrants, or orders seeking to seize journalists' information can issue, the government must first give notice and a hearing to the journalist, with the burden of proof resting squarely on the government to clearly and convincingly, the clear and convincing standard above the probable cause standard, prove the journalist in fact played a part in committing the crime being investigated, rather than requiring the journalist to prove with negative of innocence. Innocent until proven guilty, that concept is incompatible with probable cause against a journalist. 2, codify the right of journalists to challenge any subpoena, warrant, or order seeking to seize data from a third party, where that data includes the journalist's information. No more secret seizures of journalist information, period. 3, fix the Privacy Protection Act and the 2703D process to provide for clear and meaningful damages to reporters who, like Project Veritas, have to spend millions in legal fees and legal bills to defend themselves from such egregious violations of the First Amendment. What steps you take now, as members of Congress, to protect freedom of the press are essential. By the time they come to your door with a battering ram, it's already too late. The violation of the Constitution are already too egregious. The battering ram was already at my door, but your work will save the unknown reporter so this never happens again on American soil. Thank you.
Thank you. I thank all the witnesses for their testimony, and now we're going to go to the questioning part of our meeting today, and we'll start with the gentleman from Texas, Mr. Louis Gohmert. And before you start, I just wanted to point out we have a great timekeeper over there, and has the timer going, and so I know no one here ever gets long-winded, but I might, if I have to, just remind you of that. So with that, I'll turn it over to the gentleman from Texas, Mr. Louis Gohmert.
Well, I've been advocating for some time that we use number of words rather than minutes, but I've lost out on that. Mr. O'Keefe, I'm curious if the normal procedure for going after documents that may, just let's give them the benefit of the doubt, that might have been privileged that you possessed, if they had gone to court, gotten a subpoena or a warrant or actually gotten a hearing set and an order that you're not to destroy any documentation, and then served on your attorney or you that subpoena, the consequences would have been if you got an order saying do not destroy any of those documents, you could have gone to jail for contempt if you had gotten rid of them. And I continue to be amazed as a former judge and Chief Justice that the Department of Justice is not about justice anymore. So what would have been the effect if you get a subpoena and an order saying don't destroy any of these documents? What would you have done?
Congressman, we don't destroy anything, but it kind of creates a constitutional crisis when they come into your apartment and take your things in order, and then they ask you to divulge source information in order to prove that you're innocent. That it's kind of a tautology. That's what we're facing, and there are all pre-existing rules that the Department of Justice is not following. That's why I'm calling on the legislative branch to do something about it, and they have to unseal the affidavit that contains whatever probable cause was in this case, and they have failed to do that. They have not yet done that.
Well, and Ms. Attkisson, you've referred to prior case law and whatnot. That used to be the way things were done. If a reporter, if someone had information, then they would subpoena the reporter, and there would be a battle in court over whether the things that this Justice Department has just seized, whether or not they would have to be disclosed. You didn't have any of that opportunity, right? These were things that were seized without any notice whatsoever.
Secretly and without even a fake FISA wiretap. There was no wiretap in my case, no legal court action. And one of my FBI sources who helped reveal this, a former FBI unit chief who's an attorney, initially was telling me he didn't think the FBI did it before the forensics came in. He just said the FBI would never touch a journalist, that even, it used to be, if they thought they had good reason to get anywhere near a journalist, they just stayed away because that was considered so untouchable. And when he found out what they had indeed done, as proven by the forensics in my case, keystroke monitoring over a long period of time without a warrant, planting classified documents in my computer, entering the CBS system, he just said this was the worst, he couldn't believe it. He said it was the worst thing he'd ever heard of, far worse than Watergate. And that was the beginning of this sort of unraveling of trust. I think a lot of people, including those inside the FBI, had in their own agency to follow the rules. So I don't know, I take a step back and go, regardless of the legislation that's passed, if no one's held accountable and punished, if no one goes to prison for these egregious violations, they find ways to get around all of this stuff. There are so many dark operations going on parallel to the legal way that they do things that you'll never find out about. There's no budget on paper. There's no disclosure that you can find through FOIA or look at as a member of Congress. That stuff's just so entrenched inside our intel agencies. They're tripping over each other with all their operations.
Let me just ask very quickly. My time's running out. But I know there have been proposals that both of you have made about things that we could do to correct things. But having seen the way the FISA judges were not bothered that they had been lied to, fraud upon the courts, no reaction, no judge putting anybody in prison, I'm wondering if maybe it's time to go back to pre-78 and not have FISA courts anymore. Just your quick reaction, both of you, if you would.
I've heard an argument made for that that makes sense. I'm not sure, I don't know enough about the legal system to say that's the solution, but those cases, I believe Senator Graham has argued, would then be handled by local judges as they should be, with a little bit more diversity of opinion and perhaps less secrecy on important things where there shouldn't be so much secrecy. So maybe that's one thing.
There's clearly a disparate treatment at the Department of Justice, including how they define journalist in the In the amendment here, I have the quote, covered journalist. Term covered journalist means a person who regularly gathers, prepares, collects, photographs, records, writes, edits information that concerns national stories. The Southern District of New York wrote in pleadings that I'm not a journalist because I don't get permission from the subjects I investigate. So that directly contradicts common sense as well as the law. So obviously we can't trust the Department of Justice with the power to define who is and who is not a journalist, just depending upon who's in charge. That's against everything the First Amendment stands for, sir.
Thank you. And now we'll turn the time for 5 minutes to the gentleman from Florida, Mr. Gates.
Before my time starts, I'd like to seek unanimous consent that the opening statements of all the witnesses be provided to the attending members so that we might be able to submit them during the organized hearings of the House.
So ordered.
And I would further ask that all the participating members be given 5 days to submit their own opening statements for that very purpose.
Yes, and to revise and extend remarks.
Thank you. I am deeply grateful for the brave journalism that we see out of Project Veritas. I want to stay on the point you just made because one way the department will try to skirt any laws we write will be by saying, well, these are people that are criminal actors or potentially criminal actors, not actually journalists. Mr. O'Keefe, has any court found that Project Veritas is a journalistic organization protected by the First Amendment?
Congressman, yes, we've been in litigation in a number of cases, defamation cases that we've won on summary judgment, directed verdict. In fact, Project Veritas is proud of our legal record. We've really never lost a lawsuit. We've overturned the law in federal court in Massachusetts to prevent two-party consent. Numerous Article III judges have referred to us as journalists. So again,
within the judicial process, you're deemed journalists, and now there is this extrajudicial process, whether it's going behind special masters, whether it's getting third-party secret orders to turn over records related to you that seem to violate what would be a straight-up presentation of facts and review. I'm very persuaded by your 3 recommendations for the Partnicki hearing, the codification of rights to challenge third-party subpoenas, and then a pathway to damages for these violations. I was wondering if, Ms. Attkisson, you had a perspective on those policy recommendations.
I'm not a good policy person. That all sounds good to me, but I haven't studied that. I'm a little cynical in thinking, I'm of the opinion after my case happened around the 2011 time period. I'm in litigation today over this, with Department of Justice using taxpayer money to defend the guilty agents as I struggle to stay in court to get discovery to prove what I'm required to prove before we can get the forensic evidence to a jury. I'm so cynical that I believe most of what you do can be end-runned, if that's a word. Not that you shouldn't do it, because that's important, but I feel like something at a higher, bigger level needs to be accomplished to stop the abuses that we've documented.
Well, and it sucks being set up by the government and surveilled by the government, and sometimes it takes far too long to be able to clear those matters up.
May I say one little reported facet of my case is one of the federal agents involved in one of the operations against me said that they intended to plant child porn in my husband's computer. This is the FBI. There's been a case that's currently in litigation, unrelated, in which an FBI agent has testified that they did that. They have done that. It was not accomplished in my case. I guess the curtain was drawn on that facet of the operation prior to them doing it. But imagine how you ever get out of that. They knew we had a young daughter at home and had allegedly conspired to do that.
You mentioned these dark operations where elements of the FBI and DOJ use other parties to do criminal and bad things, and it appears to be some separate endeavor, but really it's driven by the core corrupt influence. But what Mr. O'Keefe's circumstance designates is they're willing to rip the Band-Aid off and use the imprimatur of government against journalism directly. And to my colleagues, what I think is quite clever about Mr. O'Keefe's policy recommendation is it requires pre-clearance. so that on those matters where they would use the imprimatur of government, the tools would be limited and there would be thresholds that would have to be achieved. And so that might be one way to not have to always, chase the tail of the corrupt actor, but instead to block them from initially being able to take those actions. And so I would also suggest to my colleagues that as we prepare for our time in the majority, Ms. Attkisson is correct. It is not enough to pass laws and believe that those laws will have their own fiat. It has to be process that blocks on the front end, and then it has to be rigorous, aggressive oversight on the back end. And based on my review of the facts in Mr. O'Keefe's case, we ought to launch an investigation immediately upon taking the majority, not just of this policy area, but of this particular circumstance regarding Project Veritas, because it unlocks so many things. Mr. O'Keefe, I learn something more every time I hear you speak about this. I had no idea that the department had tried to do an end run around a special master process. Would you mind taking a few moments to explain how you did that?
Congressman, the Article 3 judge in New York, Southern District, Judge Torres, ordered a special master be ordered in my case in a 2-page directive citing, and I quote, First Amendment journalistic privilege. After that, they went around the judge to various magistrate judges in the Southern District to obtain a secret warrant against Microsoft to continue to gag Microsoft Corporation, which houses our emails. They tried to gag Microsoft after the federal judge, the judiciary appointed a special master, citing the First Amendment. So why would we trust the FBI and the Department of Justice to define who is and who is not a journalist? And credit to Microsoft, because Microsoft opposed the gag, and when they drafted that opposition, the Department of Justice backed down. And we went public with that in March.
Thank you, Mr. O'Keefe. And now I recognize the gentleman from North Carolina, Mr. Bishop.
Thank you, Mr. Biggs. And just to follow that point up, Mr. O'Keefe, was there any reaction by the court, any discipline imposed on the Department of Justice for seeking to go and run a judicial order?
Not to my knowledge. We have filed what's called a 41G motion to get our journalistic equipment back, and the judge ordered the Department of Justice respond to that motion. They responded on Friday to our arguments, and that's where this Privacy Protection Act, they say it does not apply, and they made a number of arguments saying, and this is quite absurd, the government called our First Amendment arguments a newly invented privilege and novel theory.
That's pretty extraordinary. A point Ms. Attkisson made was about a reaction you've had from an FBI agent. And I've had an FBI agent speak to me in confidence about your situation and how what was done here by the FBI, it just doesn't fit the mission of the FBI. They don't work interstate misappropriation of property cases. The hard thing to figure out is how much of the FBI is opposed to the practices that are going on and why there can be no accountability within the FBI that would straighten this out. It's interesting to me, in light of the rigid enforcement priorities that the Department of Homeland Security, for example, seems to have. Mr. Gates pointed out in a recent hearing that there are 1.2 million illegal immigrants in the country subject to an immediate removal order, final adjudication of their rights, and the department will not act against that, but they have time to go and seize a diary of Ashley Biden's from you. One other little element to your situation that I recall, and I dug up an article about it, a December 25 article, I think it's maybe a New York Post article, I can't tell from, but it's Reuters was the source of it, that indicated a New York state judge ordered the New York Times to return internal documents to the conservative activist group Project Veritas. And it is the further is related in the text of this, that there were physical copies of legal memos prepared by one of your lawyers, and that they had been put into the possession of the New York Times, presumably through, I mean, your conjecture was through the FBI, I guess. Do you have any further insight, or can you relate anything about that to this gathering?
Well, when the agents came to our journalists' homes with the battering ram, they, within minutes, a very short period of time after the raid occurred, we received text messages from national security reporters at the New York Times, including a man named Mike Schmidt, who somehow knew the circumstances and specific situation. And then some few days later, the New York Times published our attorney-client privileged documents, and a judge in the Supreme Court of New York ruled against the New York Times doing that. That's involving a defamation case against the New York Times.
Any further developments on that point? I know the New York Times thought it was outrageous that they'd be dispossessed of your privileged legal documents, but I think people are probably rooting for you.
Well, there's clearly a distinction, and it's sanctionable conduct in New York State because we're in litigation against the New York Times for defamation, and they're publishing my attorneys in that litigation's private privileged communications, and they appealed that, and it's currently in the appellate division in New York State.
Thank you, sir. Ms. Attkisson, you're still in litigation. What is the stage of your litigation? How long has it been going on?
Maybe 7 years, and you know, many six figures later, and we've been thrown out of court. We keep coming up with new ways. As a Democrat-appointed judge found on one of my appeals prior to the current case, the courts are basically saying that I have to have all the proof of who did what before they will allow discovery in the case. I can't have proof of who did what. I have the forensics, which shows the intrusions beyond, there's no doubt there were government intrusions, but as to the specific names, I can't get that without discovery. So he noted on my side, an appeal that I lost, that it's impossible for me to prove without the evidence what they're saying I have to prove to get to court. And so that case was thrown out. We have a current case in Maryland that was because some of the surveillance was done under Rod Rosenstein at the U.S. Attorney's Office in Baltimore with a dark group, including a Secret Service agent at the time who's been in prison for unrelated corruption since then, who was involved in the spying on me and a lot of other Americans. And the status of that case is we're about to go into discovery. The case was recently assigned to a new judge. I hope that doesn't mean that judge is going to do something different. I have a clerk's award. I have won against one defendant. So I believe mine is the first case ever, even to get that far, of a clerk's award proving that a government agent spied on a journalist. I haven't seen anybody cover that in the news or be interested in it. No reporters groups have contacted me about it, but the case is moving forward as of now, and I have one clerk's judgment already.
Well, it's an extraordinary, and I, this is, I think, to a point, and I'll yield back, Mr. Chairman, in just a second, but just a closing point, Mr. Gates made this point, I think. When the gavels of committees are in the hands of a party that is interested in pursuing this issue, I don't believe it's enough to go learn about Woods procedures and the like. I believe that there must be inquiry into specific cases. There must be the gathering using subpoena power of information about what has occurred in violating specific persons' rights so that you can nail it down to the individual so that you can then illustrate what Congress must do to get the situation fixed. Because what I think is apparent to everyone is that there's no accountability. And I agree. I don't see any prosecutions. I'm not even sure what the criminal offenses are that would be prosecutable. But if they're absent from the criminal code, they must be put there. We have to know who's done what. Thank you, Mr. Chairman. I yield back.
Thank you, Mr. Bishop. And now I recognize the gentleman from North Carolina, Mr. Norman. South Carolina. Oh, South Carolina. Yeah, sorry. South Carolina. Please forgive me.
You know, this is just astounding to me. Everywhere I go in 5th District in South Carolina, people ask, is anybody going to be held accountable? And they're beginning to lose faith that they are. I just appreciate y'all continuing to speak out. The only way we're going to get to the bottom of it is saying just what you're doing here today on a broader scale. Ms. Attkisson, were you at CBS in 2010? It is, what's amazing as I listen to y'all, were y'all not tipped off at all that this was coming down the pike for you? And was in your opinion, Ms. Attkisson, was CBS what do you think their role was?
Well, that's way down a rabbit hole. I'll just say a little bit by saying at the time this happened to me, there is evidence in our forensics of CBS involvement at some level outside the news division, that at the time we had hired a security person in charge of all CBS corporate electronic security directly from the White House and the NSA. The Obama White House was working for CBS at the time. And when this was reported to him and the forensics were proven by their own, CBS hired their own forensics company to prove what my sources had found, there was no interest in getting to the bottom of it from the CBS corporate team. They didn't contact me. I had to reach out to them and try to explain how serious it was that someone had been in the CBS system. Since then, they have destroyed the records that they agreed to keep, to preserve at CBS. When I departed from them ahead of my contract, they agreed to preserve documents related to this case. The documents no longer exist. And so that's sort of, if I ever have time and ability after we finish with FBI, you know, maybe we can veer off into something else.
So Keith, I saw when you got involved with exposing Planned Parenthood, you raised a lot of eyebrows from most people who just didn't know that was going on. Were they involved? Is a collusion, in your opinion, with what's happening really to both of y'all, in your opinion?
I don't want to opine on who or what forces are behind this, or I think Ashley Biden's attorney's statement about sending it to the SDN, we should send to the SDNY, is self-evident. There's also a poster in the room. You can see the 4 photos there. We find this extraordinary, that Roberta Kaplan is the same attorney for Ashley Biden. She's also the same attorney for former Governor Andrew Cuomo, and she represents the woman married to the son of the U.S. attorney who signed all the secret warrants against me. So those are the facts. Those are pretty self-evident facts, and I don't wish to opine beyond the facts.
That's unbelievable. This is. Every American needs to know what not only y'all have gone through, but to see these facts. I was listening to Kash Patel, and Dan, you mentioned the role of the FBI. He was talking about the 42 known terrorists on the watch list now, that to track them, and I think he had done this, it takes 60 people to track them. That's the role of our government, instead of going after what you're doing. And I assume you've been banned like Babylon Bee and God knows who else.
We are banned on Twitter. Project Veritas is banned on Twitter. I am banned on Twitter, and Instagram does not allow the user to tag us. We are currently in litigation against the New York Times for defamation for calling us disinformation pertaining to a report we did on ballot harvesting, which the judge in New York ruled against the New York Times on motion to dismiss and called what the New York Times said about us. The judge called the New York Times disinformation. Said the New York Times engaged in deception, and ruled the case go to discovery in New York State.
Well, as this moves forward, and as Matt has mentioned, when we get the majority back, we'd love to do whatever we can. It's impossible to have any type hearing now, as you know. So as we move forward, we'd love to help with you. Everybody on this panel has got an interest in it. And if you hadn't watched 2,000 Mules, which I saw last night, that's as equally as scary as what you're talking about. To be able to put porn on anybody's, child porn particularly, on anybody's laptop is scary. Thank you for what you're doing. God bless your efforts. Yield back.
Thank you. Now we recognize the gentleman from Texas, Mr. Cloud.
Thank you for being here, and thank you for your work. This is, of the many challenges facing our nation right now, this has been one of the ones most pressing for me, because, we can talk about the fiscal cliff we're looking at, we can look at inflation, we can look at some of the geopolitical situation that we're dealing with, and just the rise and fall of nations throughout history. But when there's nowhere to turn to find justice, the whole idea of a free society collapses. And that's been, you know, as I weigh, like, where do you begin to start to face some of these challenges, that's been, to me, the most difficult ones. And so, you know, we can look at FISA abuse, we can look at the mass collection of data of U.S. citizens, we can see, you know, political opponents who've been targeted. Ms. Attkisson, you have been both of you have been targeted personally as journalists, but you mentioned forensically confirmed data. Could you explain that in a little more detail?
The initial forensics was done as a favor to me by someone in the intelligence community, because average people, I'm told, who would look at the computer wouldn't find this stuff. They would have, someone has to know where to go. Some of it was, and I'm speaking, just quoting what I know, I don't really know the technical aspects of this. Some of it was buried deep in the operating system of my computer. There was a BGAN satellite terminal used at times to remotely access my information. My computer was operated remotely by various actors as if they were sitting at the keyboard, keystroke program. They could turn on and did turn on Skype to activate it when it doesn't look like it's on, to listen in to my phone conversations or anything I was talking about in the room through that Skype program. The stuff and the software that they have in the computer, according to the forensics, is built into, big tech allows them to make it look like it belongs there. So if you run a virus scan, it won't look like anything's wrong in your computer because it's written into the code. So a lot of these things were detailed for me informally by an intel official. I reported it to CBS News immediately because it also, we knew they had been in the CBS computers through this forensic exam. CBS hired an independent group that came to my house that duplicated some of this work, although they had the bad actors had erased data, but that itself leaves a fingerprint. And CBS confirmed the intrusions not only in my CBS work laptops, but also my personal Apple desktop computer and so on. And then I, coincident with that, hired my own forensic analyst to have my own evidence in hand. And two separate analyses by two separate companies have continued to dig up more and more forensic data that shows the government IP addresses that were used, that were connected to the U.S. Post Office, the Postal Service. We have a lot of detail. We have some times and dates. So these, I'm told, are as good as a fingerprint and better evidence than we have that China got into our computers in various circumstances. We have better evidence than that. And it's just sitting there because I have to be able to get it into court.
And you mentioned it seemed like it went beyond just surveilling you to even trying to frame you.
I can only speculate as to why they would plant classified documents, 3 documents in my computer deep in the operating system in the BIOS section where I don't even know how to access. And that would either be, I can deduce, to be able to get a legal warrant, to be able to go to the court and say, look, someone is giving her classified material. Someone else around me may have been the target, but you know, as they get a wiretap, they can then wiretap they can surveil everybody around them. At the time, there was at least a 2-hop or 3-hop policy that one wiretap could capture 20,000 people. Right. Because they allow themselves to go beyond. They could get President Trump by getting a wiretap of Carter Page, even if Carter Page never talked to President Trump. Likewise with me, perhaps they were looking at the time for my Fast and Furious sources and whistleblowers, and by doing that, either trying to pretend that they had given me classified information or that I had received some, which would not be against the law, but it would be against the law if someone, for another person, if they had taken it or stolen it. So I don't know what they were doing. I presume it was some sort of, way to have evidence appear to be against me for something.
Mr. O'Keefe, in your case, you mentioned that you feel like you're guilty until proven innocent in your case, and that you're having to defend just your journalistic practices and the results of that. One thing that's very troubling me throughout this whole situation is the fact that all this is taxpayer funded. So we have the intelligence agencies going after individuals, we have intelligence agencies going after political opponents. It's all taxpayer funded to go after tax-paying citizens. But there's a phrase that's been coined that I'd like you to speak to if you can, and both of you can jump in. I first heard it from Matt Gaetz over here, but it says the process is the punishment, in the sense of you could end up going through this whole process, improving your innocence, but the process ends up being the punishment. Could you speak to that? What you're having to do to defend yourself?
Well, the whole idea of journalism is to get sources to trust you. And what do you think sources think when they put this journalist in handcuffs and take all their reporter notebooks? The chilling effect is self-evident. Maybe that's what they're trying to do. Either way, the legislative branch has to make sure that doesn't happen. And the problem with probable execution of a search warrant, the ACLU lawyers were in my office, which was itself an extraordinary test fact to the principles involved here. And what they informed me, this has never happened before in American history. And I want to make sure that it never happens again to anybody. You don't show up to a journalist's home with a battering ram. Probable cause against a journalist, as soon as they walk into your apartment with the battering ram and guns pointed at you, there's no remedy. The constitutional violation is already too great. You've already passed the Rubicon. So this can't ever happen again, until which time there's what I call a Bartnicki hearing, with the burden of proof has to be on the government. The federal rules of criminal procedure make this clear. The Privacy Protection Act makes this clear. Attorney General Merrick Garland made it clear in July. They just broke their own rules. They broke their own rules. So now it's upon you, with your enumerated powers, to do something about it, so that they don't do this to Josh Gerstein at Politico, or NBC News, or CBS News. They did it to me. I hope they never do it to anybody ever again.
As to other measures, if you really are interested in drafting something, I'd have to speak to my attorney, but he has implied and said he's willing to talk with members of Congress. By the way, many of my supporters are, as my attorney is, very ardent Democrats who think this is one of the most outrageous things they've ever seen, because they are free press and privacy people that find themselves on the same side as many conservatives in this arena. But one thing he says needs to be fixed. Eric Holder, Rod Rosenstein, and some others got their name pulled off my lawsuit because of an immunity protection that they have that I'm told needs to be remedied by Congress, or else they have just sort of a blanket immunity in cases like mine where they don't even have to answer the question because we're not allowed to hold them accountable for the actions that they may order if they were not directly, if we can't show without discovery that their fingers weren't on the wiretaps, they just get a qualified immunity, and that can be corrected. And the courts have said it's Congress that has to correct that. So I could get some detail passed along.
Thank you very much. The gentleman's time has expired. We now recognize the gentleman from Virginia, Mr. Good.
Thank you, Chairman Biggs, and thank you, FreedomWorks and our witnesses for this hearing that the Democrat majority clearly doesn't want to take place, let alone the American people to see it, and they certainly wouldn't permit it on Capitol Hill while they have the majority. As has already been said, there's a dangerous loss of trust in our institutions over these past few years, especially with federal law enforcement and our justice system, and that massively accelerated during and after the 2016 election. Happened with the media a long time ago, but even that sunk to a new low by the majority of the mainstream media's unwillingness to provide any accountability for the unlawful actions by their preferred political side. And now, of course, we have an administration that believes the greatest threat to America is Americans, and they're routinely weaponizing our very own federal government against us, against Americans it doesn't like, and they're destroying our foundational norms, our institutions, our laws themselves. We cannot, as Mr. Norman said, we cannot overstate how dangerous it is to the country when half the country doesn't trust the media, doesn't trust our communication channels, doesn't trust law enforcement, doesn't trust our justice system, doesn't trust our health agencies, doesn't trust our election systems, doesn't trust the federal government generally. And I think perhaps we, for decades, have underestimated how delicate our foundation of our country truly has been. So quickly unravel to things that are just unfathomable to think about, that folks like you have went through as examples of what's going on with our country. Ms. Attkisson, in your testimony, you referenced an analysis that found that intelligence agencies could use one legal wiretap to access 25,000 people's phones. Can you discuss a little more how these large-scale wiretaps, how they happen, and what do you believe Congress should do to prevent this in the future?
This has to do with that the intelligence agencies have been allowed to operate largely in the dark and grant themselves authority that is not subject to congressional oversight. So Congress didn't know at the time, is my understanding, that the intelligence agencies over the years started granting themselves broader and broader powers. One of them was, not only can they spy on U.S. citizens, which you know the NSA used to obviously never be allowed to do that, but routinely they do that now. If a U.S. citizen just mentions a code word, like Osama bin Laden, the phrase, that authorized them to listen in on that citizen. How many people typed the phrase Osama bin Laden in an email or said it on the phone over the years? That was enough to trigger a legal opportunity for them to listen in or target that person. So it's very easy for them to start listening. Then they started with the 1-hop, 2-hop rule. At one point it was 3 hops, it's my understanding, that they can not only just listen in if they get a legal wiretap against James, for example, on everybody that communicates with him, social media, emails, telephone, but then they can listen to all the people that talk to those people, all the people that talk to those people, and all the people that talk to those people. And pretty quickly, you're covering the whole United States with a couple of wiretaps. Once that was exposed, it's my understanding they're back down to 1-hop again. I'm not sure. But these are sorts of things that should be asked in oversight hearings by the appropriate oversight people. And they should be, I assume they should be told they can't make those kinds of institutional changes that involve privacy of so many people without any oversight from outside the agency.
In the testimony you provided us, Ms. Attkisson, you mentioned that these other major news network executives believe that they've been monitored by the federal government, they're surveilled by the federal government. What methods were they saying, or do they believe they were being monitored by?
They thought part of the monitoring of my family and was done of me at the time was through our computers. And they likewise thought their computers were being monitored, and they wanted to know what were the signals or how did I know. And I had to explain there will be no signs. You know, it's an invisible thing, or maybe there will be some glitches because the software they use off the books is imperfect. It's either fast or it's good or it's inexpensive. It's not all 3 things at the same time. You may notice some things. The only reason I knew those because I had sources who came to me and were able to look for this. So they were asking me, how did I know? They thought that they had clues and signals and things that were indicating the same. But to the point of the chilling effect, in the past 10, 15 years, in the past month, I've had 5 journalists tell me they don't report what they would have reported. They watch what they say. They don't want to be canceled. I mean, the self-censorship that we're all doing now is the ultimate goal because they don't even have to step in to do it. We just stop reporting the facts, you know.
We are already on the path to no longer being a free society of the United States of America. Thank you, Chairman.
Thank you, Mr. Good. And now I recognize the gentlelady from Colorado, Ms. Boebert.
Thank you, Mr. Biggs, and thank you so much for being here today. Thank you to FreedomWorks for hosting us. You know, I really have been appreciating hearing all of this and your answers that you've been giving. But Mr. Norman had mentioned, you know, it's a really sad time when there's nowhere to turn for justice. We've had an extreme 1.5 years where moms and dads have been called domestic terrorists just for showing up to school board meetings. Certainly, free speech is under attack, the press is under attack, and the White House is working with some of the press, as they like to say. But our founding fathers secured for the American people the constitutional right to free speech and the press. James Madison went as far to say that free speech rights should be absolute. Unfortunately, the Biden regime is no longer interested in protecting our constitutional rights. Since he took office, Joe Biden has continued to attack our First or Second or Fourth and so many other constitutional amendments, and on multiple occasions even said that no amendment to the Constitution is absolute. So I'm just waiting for the day that he gets rid of a woman's right to vote. But we continue to see the federal government silence any and all opposition to their radical leftist agenda under the guise of protecting the very constitutional rights they are stripping away. this is allowing the federal government to weaponize the press. To parrot their own agenda as news and any opposition as mis, dis, or malinformation. And I understand that this hearing is specifically about your experiences with the FBI and the DOJ, but unfortunately, we have been seeing the Biden regime continue to expand the federal government's censorship so much so that the Department of Homeland Security has created the taxpayer-funded Ministry of Truth, the so-called Disinformation Board, to continue to censor conservatives. Now, listening to the witness testimonies today, it's clear that the Biden regime will stop at nothing to spread its radical agenda through all means necessary, including silencing any opposition with an all-of-government approach. Now, I recently introduced the Protecting Free Speech Act, which would terminate this new Department of Propaganda we've seen established under the DHS, which is actually a militarized department. Pretty scary that they have enforcement mechanisms there. But earlier this year, the White House had admitted to coordinating with big tech to silence certain types of free speech on social media. Given what we've seen through the last year, this question is for both of you. Do you believe that the attack on journalists is an isolated incident or another arm of Biden's war on conservative speech?
Thank you, Congresswoman. For me, it's the disparate treatment, the unequal application of the law. You pointed out Madison, the founding fathers, the First Amendment specifically says press. It's a special activity that's specifically mentioned in the First Amendment, and therefore that's why this is so important. Under the Trump administration, the Department of Justice did attempt to do warrants against Google for New York Times information, but allowed Google to disclose the presence of those warrants. It got to New York Times lawyers. They were able to fight them, and it went away. In our case, that did not happen. The Department of Justice did not allow us to know the existence of the warrants. In fact, they gagged using magistrate judges, Microsoft from telling anybody about that. That's should not happen on American soil. And it's the disparate treatment under the law that we have to get redress for.
I see the crackdown on information and what happens to the press, and I take more of a long view. This has gone on for decades at least, probably further back than I've been able to track, just based on the public information that we have. And I think the intelligence agencies have become very untouchable and very controlling. They persist from administration to administration. It doesn't really matter very much who's in charge in terms of who's president, because the same actors may put their heads down publicly but continue to operate in the dark the same way they were. So I think it's a bigger problem that can be resolved by a different president or, small measures. This is something that we probably needed to address 50 years ago. Quick reference to Quest Communications back before 9/11, telecommunications company. The CEO of that company told me a story, and I did a piece on this a couple of years ago. All the phone companies were cooperating with hundreds of millions of dollars of contracts for the intel agencies back before 9/11. And when he refused at one meeting with an NSA official to start turning their surveillance on U.S. citizens, which he told the NSA official he didn't believe they had the authority to do, he ended up in prison for something unrelated that they supposedly caught him doing, having to do with trading. I mean, this was a very chilling thing. This man went to prison. He was the only telecommunications agency that bucked the NSA to start spying on American citizens before 9/11. This stuff goes way back, and I think it's very, very deep.
I thank the gentlelady. Her time has expired. And now I recognize the gentleman from Ohio, off a big electoral win the other night, Warren Davidson.
Thank you all. Thanks for organizing this hearing. Thanks to FreedomWorks for hosting us. And Ms. Attkisson, Mr. O'Keefe, thank you for the work you do. You can't really defend freedom without defending a free press. And thankfully, our founders recognized it. And unlike so many other countries in the world, we have a constitution that protects it. I'm increasingly concerned, and even more as I sat here and listened to the dialogue. Just going back to, you know, your reference to the Quest CEO and your own family's experience where you had agents willing to plant information, recent history where we saw the FBI basically organize a kidnapping of a governor of one of our states in order to frame people that might be willing to go along with the plot. That we might be going about this the wrong way. You know, we kind of sometimes think, well, maybe they just don't really know what they're doing. I know when I first got to Congress, I was pretty naive, and you know, Christopher Wray had just taken over as the director of the FBI, and I wanted to politely, in a sidebar conversation, say, look, I will really wish you well, because what you're doing, taking over as the new director, is really important, because the American people do not trust this organization. They clearly don't trust your predecessor. They don't even know you, but I hope you can restore the trust. Well, obviously it hasn't gone well for trust at the FBI since you know, early 2017 when Christopher Wray took over as the director. But I was rewarded for that by really creepy behavior as I was leaving the building. Not any building, the United States Capitol, as a member of Congress. I see all these people with large telephoto lenses, bazillion rounds, frames, taking pictures, you know, stuff that was overt enough to be like, this isn't regular journalism. I'm not Matt Gaetz or anything. People aren't taking pictures of me like that. You know, that's the only time that's ever happened the whole time I've been here. It was right after I just asked, hey, we need your agency to be successful. I wonder if maybe we don't just need different people. So you think about like the idea that you're going to reform an organization by keeping all the same people in all the same chairs and playing by the same rules. Perhaps we need a completely different org chart, a whole different structure for this. And I wonder if we were to look at this in a blank slate, if either of you have given thought to how might we ought to be organized.
Not, maybe James has an answer to that. I would just say I agree. When they brought in Robert Mueller to do an investigation in a case that had done Woods procedures violations that happened under him, or the reforms when he was FBI director, it starts to feel like just the same people are coming back and somehow get appointed to be the overseers. And I don't know how you root that out from top to bottom, but I think you're right. The same people keep coming back, and you're not going to have big changes. I don't know if you were here earlier when I pointed out that Christopher Wray gave false testimony to Congress in claiming there had been no 702 surveillance abuses. That's just completely false. And no member who was sitting there, no offense, it wasn't this committee, but not one person said, that's crazy. There's lots of documented abuses in the record. Everybody just kind of nodded. And I think that's a big deal.
Good point.
Yeah, I think that accountability really, from our perspective as news people, is sunlight. That's the accountability. You all derive your power from the consent of the governed. So that consent can't be manufactured. And what has happened here, and what I've testified about, the battering rams, the handcuffs, rifling through notebooks to identify sources, we have sources in the government who have been chilled out from coming forward to educate people and outrage them about what's happening in the intelligence agencies. And they can't do that. So for me, it's circular. And that's why there has to be this reform. There are rules. There are criminal rules of federal procedure and Privacy Protection Act and Attorney General's own memos. They just violated it. So that freedom to bring the information forward, and there needs to be some standard. It's on the government. If they're going to raid a journalist's home, again, I go back to this concept that there has to be a clear and convincing standard. It can't just be, we need to look through your anonymous sources so that you can prove that you're innocent to us. That has to be changed.
Yeah, you've highlighted some really important laws that do need to be changed, but none of them are been successfully enforced. I mean, I had one that was just so basic. To your point, Ms. Attkisson, when there are violations, we just wanted a summary of who violated these rules and what disciplinary action was taken. It could have just been benign and they weren't well trained. It could have been, you know, something small enough that there was some disciplinary action. Was anybody ever fired? Was anybody ever prosecuted? And we even got it through the House once, only to be stripped out of the Senate. So there's not even that level of accountability. So I think we may have to change the whole org chart and dismantle some of what's already created. And obviously that's a pretty big lift because we have ongoing needs. It is vital that we have national security, but thanks for highlighting the balance that is definitely askew right now. I yield.
Thanks. I think it's the gentleman from Ohio. And so, Ms. Attkisson, when you were testifying earlier, and you're talking about the forensic analysis by, I think, a total of 3 different CBS plus 2 privates, one of the things you mentioned, and I want to make sure I understand it, was I thought you said there was some tie to the United States Postal Service in there. Can you elaborate on that for us?
Well, I don't want to get too far out of my lane forensically, but there is a way that we were able to prove forensically what IP addresses that are non-public that should not have been accessing my computer from the outside were. Despite the fact that the bad actors did erase a lot of data, there was some fragments of data that had been saved. And so we were able to trace what data that was, what IP addresses they came from. We went to, with the help of some members in the Senate at the time, the Postmaster General, and asked them to investigate this. And I was called in and treated like a suspect by the Post Office Inspector General's office. And the man who, Mr. Duckworth, asked me some questions, told me his job was to figure out where the forensics were wrong, because it couldn't be that their IP addresses were in our computer. So that's how they approached their investigation of this.
So I appreciate that, and the reason that I raised that is because I don't think any member of Congress really knew until just a couple of years ago that there was a kind of an investigative arm of the USPS, and so to see that you were victimized by that group was pretty astounding. And then just some of the things that we've heard today, they were not just busting down your doors and stealing your stuff. They're trying to plant information in your computer. That is just, I mean, everything we've heard has been totally outrageous. And when we talk about blowing up and starting again, not just the org chart, but I mean, I think of FISA. I think FISA I think there's a handful of members who voted against the reauthorization, as I did, because it's so prone to abuse. And then it was revealed like 2 weeks after the vote on the floor. I find that to be undeniably coincidental. So the other thing, too, is I wanted to ask you, Mr. O'Keefe, about the Southern District of New York and the U.S. Attorney's Office there, recognizing that I don't want you to prejudice yourself in any way, but I am curious to know how they have proceeded and from an ethics point of view as they've been involved in this with regard to Roberta Kaplan.
Well, the graphic there speaks to the relationships. Again, she's the lawyer for the daughter-in-law of the U.S. attorney who signed the secret warrants. We understand the law of the land is that you need permission from the Attorney General of the United States to execute a search warrant, for the FBI to execute a search warrant against a press media company. I'm not aware of that ever happening before in American history. That's what the ACLU told me. They're defending Julian Assange in his case, but we have no reason to believe they went to Maine Justice to get that approved. Either way, their attempts to say that I'm not a journalist in opposition to the special master is absurd, and their recent last week response to our return of property motion, completely ignoring any First Amendment argument that we made, shows bad faith.
Did Judge Torres know about the second court order?
I'll have to check with counsel on that.
Okay, I was curious about that. How did you find out about the second route that the FBI was using?
Second route,
Yeah, I mean, as far as they were going around the special master.
we found out because after the federal judge appointed the special master in, I believe it was December 8th or thereabouts, there was warrants that were unsealed later showing they went to try to gag Microsoft Corporation with these 2703D gag orders to try to prevent Microsoft from telling anybody about what happened after the case was public and the federal judge cited First Amendment privileges. So for the Southern District to continue to shop around the magistrate bench of New York to try to continue to silence Microsoft, that behavior is beyond unethical. And Microsoft, credit to them, fought back, and that's when all these warrants became unsealed and we found out about it.
Thank you. We our time has expired, but I will say this has been very enlightening. It's outrageous, and it's probably more than outrageous. It's so Soviet-like. It's unbelievable to me. I appreciate that both of you would come in, and Ms. Dhillon, who was here earlier, also testifying. And I think some of the potential solutions that you've offered are really worthwhile, and I think that Mr. Gates' idea that we should be going and setting up to have oversight hearings and investigative hearings immediately upon the change of gavel are important. And so I call upon our Republican leadership to send the preservation letters necessary to the leaders of these agencies, as well as appropriate actors in these agencies, so we'll have those documents preserved for the time we can actually bring them in through subpoena and begin to do what needs to be done. I also call upon my Democrat colleagues, many of whom are outraged by this type of conduct by the police apparatus of the United States of America, to also join us in calling for preservation of these documents and hearings immediately to hold those who are responsible accountable. With that, I'm grateful that you were here. Sorry that you're undergoing this this harassment and frankly, more than harassment, this illegal conduct on the part of our own government. And I appreciate my members who are here today and the staff that worked so hard to put this together. Yes, I'll yield to Mr. Gomer.
If you were told that all of the things that happened to these people had been done by Putin's government or the Communist Party of China, would you be surprised?
You know, it reminds me of, if you go back and read Solzhenitsyn, anything by Solzhenitsyn or others, that's what you see. This is what you saw. Same thing with anything regarding to East German Stasi or anything like that. That's what this is. So it's outrageous, and it has to be brought to an end. And with that, we are adjourned. Thank you all.